All right, so welcome everybody. My name is Alex Alanis, and today we'll be doing residential listing agreement part one. This is the updated version of the listing agreement. I do believe it came out in June of 2020. So there was some changes when we saw the clear cooperation and also coming soon options for the status on MLS. So just to let everybody know, I'm not an attorney and or an accountant, but I am a licensed real estate agent and I like to share. So you guys are welcome to participate and or chime in. And so we'll talk about that some more, but this is part one of 3 different parts, and we'll be doing these 3 in December for this Wednesday and then the next 2 following Wednesdays. And then what we'll do is we'll take a break for the Christmas break and also in through January. I believe the next class that we'll do will be on the 12th of January. Thank you guys for joining. Robert Sully, I think that you did see the original version of the residential purchase agreement, but there has been some changes since then. So there'll be some new stuff on this. Okay, so there's my information. You guys have it. Feel free to call me or email me anytime. I'm always privy to questions and what have you. I do appreciate you guys muting yourselves. Now I do mute you guys on my end, but if you care to chime in anytime, feel free. And then also there's the chat box that you can use with Zoom as well. Feel free to ask any questions there if you like. I try to get to the questions at the end of each slide. Okay, so you know, this class really all is about, and what I would like to think of is more of a dialogue versus a monologue, right? Just me talking. I would rather be talking with you guys about, you know, and discussing what it is that we're looking at when it comes to these contracts. And so feel free to chime in with any questions. Okay, there's no question that's dumb or stupid. Okay, they're all very viable questions. And it's because people learn at their own pace. They learn at different paces, and there might be some beginners, and you know, as always, and so I'll put up the next one there. You know, feel free to invite anybody. You don't have to be licensed to come out of these trainings or presentations. You don't have to be, you know, you can be 14 years old. You know, maybe you're interested in a real estate career or something in real estate, and you want to learn about this stuff. So this is all good information. So any age, any license bracket, anybody that's interested, I'm here to share. Okay, so I appreciate you guys logging on early as we like to get started, so we don't go too long. There are 24 slides in this presentation, so this one might go a little bit longer, so I'll try to be swift in the presentation. Any questions or comments so far? Okay, so let's get started. Okay, so this is kind of a little bit of some rehashing of some of this information, but I like to go over these things more than once sometimes, just to kind of really drill it in terms of what it is that we're doing. So to understand what a listing is, one must first understand what it is we do as licensed agents. Okay, so this obviously is part one of 3. This course has been separated into 3 parts, which typically is in separate classes. This course will cover the following, and that's today. We will be covering the agency disclosure and or the agency relationship, the PRBS, possible representation of more than one buyer or seller, the residential listing agreement, right, will be covered in part 2 and 3. And then today we'll be going over the seller's advisory. And on part 3, we'll be going over the wire fraud advisory. And excuse me, there is a new form that I will probably incorporate into part 3, because I think that's probably the shortest of the 3, which is the fair housing advisory. And then there's also another new one called the CCPA, which is the California Consumer Privacy Act, or privacy advisory. So that's the other one that's included anytime you open up an RPA pack or residential purchase agreement pack, those disclosures are automatically in that packet. Okay. And then there's the ESP, which is an estimated seller proceeds, which is not a required form, but I like to use it, and I'll explain why on part 3. Okay. So any questions or comments on that? All right, so let's keep moving. So the AD, right? Why? Despite what is popular conversation in the real estate business, real estate agents, realtors, do not buy or sell real estate. That is, if it is not their property. So meaning that unless it's their property, the real estate agents don't sell property. Okay. Real estate agents facilitate transactions. That is a disclosure that covers this precisely. It's called the AD, or disclosure regarding agency relationship. Okay, so we've covered this before with the residential purchase agreement, but again, I want to reiterate some of this information because it's important. It's important to understand that real estate agents don't sell property. We advertise and we facilitate. Right? Any questions or comments on that? Because we're about to cover it. All right. So this was, it appears to be an advisory that was updated and revised on December of 2018. And we are still using the same one. I know that the RPA will be changing this month on the 21st, unless they move the date back again, because they've done that several times. I don't know that this one's going to change, but there is some new forms that are coming out. Now, this one is pretty self-explanatory. And before, it used to be where the seller's brokerage advisory was different from the one from the buyer's brokerage. But now what they did is they incorporated them together. But it's the same wording. Okay, so here we have, when you enter in a discussion with a real estate agent regarding a real estate transaction, you should, from the outset, understand what type of agency relationship or representation you wish to have with the agent in the transaction. Now, this is what we normally find in when we do real estate. But you have to ask yourself, well, if there's this, can there be something different? And yeah, you know what? A client can give you like full autonomy on buying something. You know, they can put their eye on something and say, you know what, I want that. I just don't have the time to do it. Mr. Agent, can you do this for me? That would be a different kind of relationship. So understand that the real estate agency relationship, what we're doing here is we're defining it. Okay. So seller's agent on a listing agreement, the seller acts as the agent for the seller only, right? A seller's agent or a sub-agent of that agent has the following affirmative obligations: a fiduciary duty of utmost care, integrity, honesty, and loyalty in dealings with the seller, right? Diligent exercise of reasonable skill and care in performance of agent's duties, a duty of honest and fair dealing and good faith, and a duty to disclose all facts known to the agent affecting the value and desirability of the property. An agent is not obligated to reveal to either party any confidential information. Okay, so that said, does it say anywhere there that it's the duty of the agent to sell a property or even buy a property? Well, in this case, it would be seller's agent, right? So is it the agent's duty to sell the property? No, it's the agent's duty to facilitate it. So it's a little different, okay? Because the agent isn't signing any documentation that has anything to do with selling the property. Believe it or not, the agent only signs a few advisories and they sign for their commissions. And that's about it. The agent acts more in terms of disclosure, right? And acts more in terms of pointing their client in the right direction. So if they need a home inspector, oh, okay, yeah, you know what? Look on the internet, you can find home inspectors there, but if you don't find any there that you like, I can refer you to 3 different ones, right? That could be a conversation that you could have with somebody. But what you're doing is You are acting honestly and dealing fairly and in good faith on those things, because in terms of a home inspection, one could think that they could be steered towards a home inspector that could be unfavorable, right? So this is the reason why it's important that we give multiple options. But again, it leans back towards the agent being honest or playing honestly. Okay. Any questions or comments on that? Okay, so on the same form, we have the buyer's agent roughly, or identically, has exactly the same information, right? As to the buyer's agent's duties and how they deal with their client, right? It goes along with, and sorry, I thought there was some highlighting on that one, but it goes along with, again, a duty to disclose all facts known of the agent materially affecting the value or desirability of the property. A duty to disclose, right? So even though a buyer might tell you, oh, well, I don't want to give this information to the seller, I'm sorry, Mr. Buyer, but I have a duty to do that. I'm obligated to do that. And that has to do with, again, with dealing in good faith and being honest, right? The topic of exclusive agency will be discussed in a different class. And that's because exclusive agency, again, holds some different responsibilities, if you will, okay? Any questions or comments on that? So now we have dual agency, right? So a real estate agent, either acting directly or through one or more salespersons and broker associates, can legally be the agent of both the seller and the buyer in a transaction, but only with the knowledge and consent of both the seller and the buyer. So they pretty much have to know that you're acting as dual agent, right? A fiduciary duty of utmost care and integrity. So it's pretty much the same. You're acting exactly the same. Other duties to the seller and buyer as stated above in their representative sections in representing both buyer and seller. A dual agent may not, without the express permission of the prospective party, disclose to the other party confidential information. So confidential information could be a social security number, which normally we don't have, but that's something that we wouldn't rightfully give out to somebody else, even in a regular transaction, right? And I apologize, I forgot to silence my phone. But it also goes along with price. Okay, now you'll see in the listing agreement that we wouldn't normally have that conversation with the other agent, but we certainly don't want to have that conversation with the other side, especially if you're also their agent as dual agent, right? So it goes along with saying, including but not limited to facts related to either the buyer and seller's financial position, motivations, bargaining position, or other personal information that may impact price, including the seller's willingness to accept the price less than the listing price, or the buyer's willingness to pay a price greater than the price offered. So this is how a conversation should go. Hey, Mr. Agent, and let's just say that I'm the seller. Hey, Mr. Agent, hey, what do you think the buyer's willing to pay for this? They're your client. And I'll just say, well, Mr. Seller, I will go to the buyer and I'll see what they want to put in writing. Because you really can't be suggestive in terms of what the buyer or seller is willing to do, because they're both your client. You would be acting out of line, right? And that would be considered to be confidential information. And I highlighted price here a couple of times because that's probably the most important part. Okay. Either the purchase agreement or a separate document will contain a confirmation of which agent is representing you and whether that agent is representing you exclusively in the transaction or acting as dual agent. The above duties of the agent in real estate transaction do not relieve a seller or buyer from responsibility to protect his or her own interests. And that's mainly because a lot of the stuff that agents do actually don't protect the buyer or seller. They have to get these additional things, typically termite report, home inspection, sewer inspection, roof inspection, plumber inspection, electrician, appraisal. There's so many other things that a buyer can do, and even a seller can do preemptively on a property. You know, let's say they list it and they can get some of that information, but the agent doesn't do any of that stuff. So I'll read it again. The above duties of the agent in real estate transactions do not relieve the seller or buyer from the responsibility to protect his or her own interests, right? You should carefully read all agreements to ensure that they adequately express your understanding of the transaction. A real estate agent is a person qualified to advise about real estate. So I talked about facilitating, right? Recommendations and advice is the limit of our expertise, okay? Usually the advice is coming in the form of, oh, well, you need to talk to an attorney, or, oh, you need to talk to an accountant, or, oh, you need to talk to the escrow agent, or, oh, you need to talk to the appraiser, or I'm sorry, the lender, because normally they wouldn't talk to the appraiser. Oh, maybe you should talk to the home inspector, right? That's usually as far as the advice is going to go, right? If you're going any farther than that, you're probably overstepping. So it goes along with saying, if legal or tax advice is desired, consult a competent professional. If you are a buyer, you have the full duty to exercise reasonable care to protect yourself, including as to those facts about the property which are known to you or within your diligent attention. And I'm sorry, I got something popping in here. Both sellers and buyers should strongly consider obtaining tax advice from the competent professional, because the federal and state tax consequences of transaction can be complex and subject to change. And that's important. Okay, so you'll see this as well as some of the addenda that comes out, say on the statewide addendum, the SBSA, that information is said again. So this is a redundancy. Throughout your real property transaction, you may receive more than one disclosure form. And actually, there's many disclosure forms, depending upon the number of agents assisting in the transaction. The law requires each agent with whom you have more than casual relationship to present you with this disclosure form. You should read as its contents each time it is presented to you, considering the relationship between you and the real estate agent in your specific transaction. So you'll see, and we've pretty much gone through this entire disclosure, just short of the signature section and then obviously the disclaimers, that nowhere here does it say that the real estate agent is buying or selling your house, right? Their duties are simply really just to facilitate and advise, right? So this is where it's important how we understand what our position is in the transaction, because a lot of agents overstep. Let's say, oh, well, you know what? I don't use that NHD company, so I'm just going to go ahead and order from this other NHD company, even though in the contract it says a different one. Well, that's a no-no, right? But that's an example of what agents do, and I've seen it happen many times. Typically, you would need an addendum where buyer and seller have agreed to change the NHD company. The agent has absolutely no power over doing something like that, even as simple as an NHD report. It should be in writing. So understand that if something like that is done, there could be ramifications, suspensions, fines, violations of some sort if your file is audited. Now, we don't hear a lot about that, mainly because most people that are audited and get in trouble, they don't talk about it. And quite frankly, the majority of auditing that goes on typically is kind of scattered. So we don't see a lot of that. So we kind of have to police ourselves. So understand that this is why this information is important. So any questions or comments on that? All right. Oh, so I did highlight some other sections here. The law requires each agent with whom you have more than a casual relationship to present you with this disclosure form. When they talk about this disclosure form, okay, we're talking about the AD, the agency relationship form, which is on every listing agreement packet as well as the purchase agreement packet. Okay, and if right now, if you look at 2A on the RPA, it says that both parties have a copy of this in a transaction. But you'll see on the new RPA, those of you that have had the opportunity to read it, it actually says that there's no legal requirement to share this disclosure with the other side. So if I'm working with the buyer, I don't necessarily have to give it to the seller, as long as I have it in my file for my client. So that's the important part, okay? I'm not sure why that is. I will be doing some more investigating in terms of why certain things are happening and why they're not. And then I'll just kind of bring them to you as I get that information in form of the nuggets that I usually put out there. So any questions or comments on the AD? Well, I did highlight some other areas. So specifically, the real estate agent does not discuss price to the other party and certainly does not consult on matters outside the scope of their license. So that's just some reiteration of what I mentioned earlier. So you'll see throughout the presentation, you're going to see some names, and they're used here primarily just to just as an example. Okay, these are examples that that are put up. So if you are taking any pictures of any kind, just be discreet with that information. Okay. So this is the signature section. You'll notice that the buyer, this can be used for buyer, seller, landlord, or tenant in terms of the agency relationship. It is important to notice that this form can be used for buyers and sellers and landlords. Signatures can be obtained digitally or manually along with the date. Whenever signing, please do not forget the date. And I will reiterate this, as I always do, is that anytime you're signing a document, whether it be digital or otherwise, it should always be dated or it's not considered executed. And that's California signature law, okay? It has to have a date on it, especially when you're dealing with advisories, disclosures, and contracts, okay? Any questions or comments on that? All right, so let's keep moving here.
No.
Okay. All right, so this is page 2, and the reason why I shrunk it down really small is because it's primarily an example, but it does have the actual law in the first couple paragraphs there. So page 2, the AD are identical for buyer and seller, and like I mentioned before, it's not 2 pages anymore. It's just, I'm sorry, it's not 2 different disclosures now. It's just one, and it includes buyer and seller. Before, they used to have separate buyer and seller ADs or agency relationship disclosures, right? But the civil codes 2079.13 and 0.24, right, are included on page 2, and it talks about it there. There's a sample section that is usually found on the agency confirmation on the residential purchase agreement that does not need to be signed on this form. And this is why page 2 doesn't have a signature section, okay? It's simply just as an example, and also to clarify what the law is in summary, okay? So there is specific, or this here is specifically so that all parties can identify who is their representation, okay? Not sure, you know, you would have to be really, really out there not to know who's representing you, but to be clear, it goes along with the rule that everything should be in writing, right? So yeah, we all do understand who our agent is, but I'm getting it in writing. So there's no mincing words here. This is my agent, and this is the person that I chose. And there's the example there, and you'll see that on section 2 of the RPA, okay? Even though this is residential listing agreement, this form is also included with the listing. Any questions or comments on that? All right, so hiring a real estate agent is a lot like hiring a photographer. You get what you pay for. Okay, that's just funny to me. I gotta crack up out of that one, but anyway. All right, so seller's advisory. So this is an advisory that comes along with the residential listing agreement, and we'll just go through line by line here, and you'll see some of it is actually pretty eye-opening in terms of, you know, what we're telling our clients. So The introduction, seller property in California is a process that involves many steps. From start to finish, it could take anywhere from a few weeks to many months, depending upon the condition of the property, local market conditions, and other factors. You have already taken an important first step by listing your property for sale with a licensed real estate broker. Your broker will help guide you through the process and may refer you to other professionals as needed. The advisory addresses many things you may need to think about and do as you market your property. Some of these things are requirements imposed upon you either by law or by the listing or sale contract. Others are simply practical matters that may arise during the process. Please read this document carefully, and if you have any question, ask your broker or appropriate legal advisor. And so there we go again. It's referring to you consulting with an attorney or an accountant. Okay, but more importantly, it actually talks about the three pillars that we have discussed previously. And what were those three pillars? Statutory, meaning required by law; contractual, meaning something obviously written and agreed to by buyer and seller, so it's contractual now, right? And signed and dated, right? But then it talks about what I call the third pillar, which is civil, but here it calls it a practical matter, which if you think about it, when you talk about civil issues, they're practical matters. These are things that would potentially be important and potentially you could get sued for them. So they are practical, very practical matters. So those are the three pillars that I'm talking about, right? So it talks about it here. And sorry, there's still logging in here. Talks about it here. And whereas normally you actually may have that conversation with your client, but if you didn't, okay, when your client is reading this, now it's being clear as to what they're doing in terms of selling their property and what they may be obligated to do. It addresses the things that sellers need to think about and do. And, some sellers, you'll find that they'll be very conducive and want to do the things that you ask them to do and that you talk about. Others may not. Others are more about the money and they don't care about some of these things. And sometimes they don't care about the practical matters. Now, contractual and statutory matters, well, that's a different story. But the practical matters, a lot of times there's some gray area, right? So any questions or comments on that one? That's paragraph 1 of the seller's advisory. So let's move on to paragraph 2, disclosures. Okay, so you must affirmatively disclose to buyer in writing any and all known facts that materially affect the value or desirability of the property. Now, earlier in the AD, it said that that's the agent's responsibility. Well, wouldn't it make sense that if they're your client, and let's just say you're representing the seller, that the seller, you are now getting in writing and advising them, Mr. Seller, you have to disclose in writing, and I'm going to give you the tools to do that through all the disclosures. And those of you who are familiar with the disclosures, you know what disclosures I'm talking about. I'll just kind of lightly tell you about a couple of them, like the TDS, the SPQ, right? The SBSA, the FLD. These are all transfer disclosure statement, seller's property questionnaire, and lead-based paint. So we're giving the seller the tools to answer a lot of the questions that may be known material facts that affect the value and desirability of the property. Now, when you say value and desirability, that's like a blanket statement. Like we're talking about everything now, right? So they're giving it to you as the agent. So now you have to honestly disclose that same information to the other side. And or if you happen to be dual agency to the buyer or the seller of the property, right? You must disclose these facts whether or not asked about such matters by the buyer, any broker, or anyone else. This duty to disclose applies even if the buyer agrees to purchase your property in its present condition without requiring you to make any repairs. So there's the as-is clause again. Now we talked about section 11 on the RPA, okay? That talks about that the property is being sold in as is present condition. Let's not confuse that with the seller's obligation to disclose. So it goes along with the first sentence, right? Any and all known facts that material affect the value and desirability, even though they're buying the property as is. So a lot of people would think, well, you know what, they're buying the property as is. Why do I need to tell them anything? Well, it's because they need to know. And there might be something there that's so undesirable that now they don't want the property, they want to cancel. Well, they have cancellation rights. So understand, this is why it's important to actually disclose to the buyer the information. Here's where we're telling the seller, Mr. Seller, you have to cough up this information. You have to give this information to the buyer. Doesn't matter if you're selling the property as is. So it's not as convenient as one would like to think, because a lot of people misuse the as is clause, or they just use, it's semantics. They misuse that word to mean, oh, you take it the way it is and too bad. Well, that's not how it works. Okay. And so we need to understand that, and we need to relay that to our clients. Did you have a question, Lupe? Okay. All right. So moving on. Broker cannot advise you on the legal sufficiency of any disclosures you make if the property you are selling is a residence with one of 4 units, except for certain subdivisions. Your broker also has a duty to conduct a reasonably competent and diligent visual inspection of the accessible areas and to disclose to a buyer all adverse material facts that the inspection reveals. And that's the AVID. We'll be doing a class on that probably in February. I'm thinking probably February. If your broker discovers something that could indicate a problem, your broker must advise the buyer. So obviously, first, because again, this is the seller's advisory, you would be discussing that and putting in writing with your client, but you have an obligation now to also forward that information out to the buyer, right? And I keep forgetting about the highlights, but I went through the whole thing, so I guess that's good enough. It is not the agent's responsibility, except in specific instances, to disclose to the buyer. It is the seller's responsibility to disclose to the buyer. In the last section, who can be liable if the broker fails to disclose? So it actually says if your broker discovers something that could indicate a problem, your broker must advise the buyer. So if the broker doesn't give information that they have to the buyer, who could be liable now? Anybody? Well, it's an obvious answer. I'm sorry, Dion, what'd you say?
The broker.
Yeah, the broker. Okay, I appreciate that. Yeah, the broker and agent. If the broker and agent don't disclose that information, yeah, guys, you're obligated. So understand now through this disclosure and the agency disclosure that we just went over, that those 2 disclosures together mean that both seller and agent are as responsible to disclose this information. Any questions or comments on that slide? Excuse me. So let's move on to section B, statutory duties. So you must timely prepare and deliver to the buyer, among other things, real estate disclosures, the TDS, the NHD. You have a legal obligation to honestly and completely fill out the TDS form in its entirety. Many local entities or organizations have their own supplement to the TDS, and I've seen a few of those, that you may also be asked to complete. The NHD is a statement indicating whether your property is in certain designated flood, fire, earthquake, seismic, or hazard zones. Third-party professional companies can help you with that task. And we talked about property ID, which happens to be our endorsed NHD company, but there's many of them out there that are reputable. What I always look out for mainly is that the NHD company has errors and omissions insurance, because please understand that because the seller is obligated to give this information through NHD, it's important to use a reputable NHD company, because if the NHD is incorrect in any way, guess who's liable? We just talked about it, the broker, okay? The broker's liable because now the broker may not have disclosed the proper information because the third party that you used, meaning the NHD company, was incorrect or inaccurate in what they were reporting. So this is why it's important to use a reputable NHD company. So let's move on to number 2. Depending upon the age and type of construction, and I don't know what just happened to something here. Depending upon the age and type of construction of the property, you may also be required to provide, and in certain cases, you can receive limited legal protection by providing the buyer with booklets entitled Homeowner's Guide to Earthquake Safety, Commercial Property Owner's Guide to Earthquake Safety, Protect Your Family from Lead in Your Home, and Environmental Hazards, a guide for homeowners and buyers. Some of these booklets may be packaged together for your convenience. And primarily, there's a third one, and I think they mentioned it here. It's the home energy booklet. The earthquake guide asks you to answer specific questions about the property structure and preparedness for earthquake. You are required to supply the booklet about lead. You will also be required to disclose to the buyer any known lead-based paint and lead-based paint hazards. The environmental hazard guide informs the buyer of common environmental hazards. So there is a packet that has all 3 booklets, and I advise every single person on every single transaction, so this is just my recommendation, to always include it, because you'll see that in some situations, some of the properties might be newer, and then the agents will say, oh, no, it's not required, okay? But you'll see in the notes on the disclosure chart, if you go all the way to the bottom, it has the little notes. It says that even though the information is not required by law, it could be helpful to the homeowner. So why not give it to them, right? So that's just my little nugget on this particular slide, is that on every single transaction, you should be giving all of those booklets out to the buyer, always. It's just one of those practical matters that we talked about earlier, or what I call the civil pillar, okay? And I think Dion has a question. What's going on, Mr. Dion?
Yeah, Alex, you were talking about for NHD companies that only certain ones are kind of covered under E&O. Under zip forms, when we're inputting the contract, there is a list of NHD companies to use. Those are obviously approved companies, right?
Okay, that I don't know. They're probably endorsed by maybe some of the boards, and that's the reason why. But we just have to be careful that when you see stuff like that, this could be companies that are actually buying into being there. Not that they're endorsed by the company in zip forms. They might even have a little disclaimer at the bottom saying that that they have no affiliation or that kind of thing, right? So it's just something to be careful for. What I would recommend on an NHD company, okay, that is reputable, normally they would have errors and omissions insurance for the NHD company. And a lot of times they'll actually give you the E&O rider, like I know Property ID, they actually give you the page where it shows you, how much they're covered for and what have you. So, the important thing is this: if you have a listing and you're dealing with the seller, investigate the different NHD companies. Maybe talk to some comrades, talk to some brokers, talk to some colleagues about what their experiences are with certain NHD companies, and they'll tell you who they recommend, right? I've told you who I recommend, right? Mainly because I have investigated that company. I have looked into the way that they report, the way they get their information, and I have confirmed that they have E&O insurance. So that's the reason why I recommend them. But it doesn't stop you from using other companies, because there are other companies that are as reputable. What I'm getting at is there are companies out there that are not reputable, and I've seen that, and they don't have E&O insurance. So these are the things to look out for. I hope that answered your question.
No, it does. Thank you.
Right on. Yeah. So in terms of what you see on zip forms, remember that a lot of that stuff might just be advertisements. So you just got to be careful with that. And if you are going to use one of those companies, just investigate. Ask some comrades or give me a call. I'll see what I can do about investigating your request. But in terms of the statutory duties, we're now being clear now with the seller, Mr. Seller. Number one, you're going to have to fill out a TDS, and number two, we have to give the buyer an NHD. we have to give the buyer these booklets, these earthquake and lead-based paint and energy booklets, environmental hazards booklets, right? Again, you're gonna find some agents that say, oh no, it's not required, and they don't want to cough it up. Doesn't stop you from delivering it to your own client. Okay, if you're working with the buyer, I do it all the time. Okay, there's nothing wrong with doing that, as long as you have confirmation that they received it. Okay, so any questions or comments on that slide? So the transfer disclosure statement and the natural hazard or NHD represent the property in different ways. The TDS, everything within the site perimeter, and the NHD, everything outside the site perimeter. So you'll see that really what's being meant to happen here is that the seller is responsible with the NHD, which is statutory, means it's required by law to fill out the TDS. That's everything inside of the fence lines, right? So anything inside the fence lines. The seller can't really be responsible for things outside of the fence lines because they don't own that property. They may not know much about it. But guess what? An NHD company would. And they talk about those different things, about earthquake, fire areas, flood areas, noise areas, right? Wildlife areas, fire hazard areas. These are all things that the seller may not know anything about really because they're not an expert in that field, but because we have the technology to be able to get these reports fairly quickly and inexpensively, why not? So they made it a requirement, okay? So the combined booklets, EPA, energy efficiency, homeowners equity, safety, and lead-based paint are usually readily available by local vendors. And so I know a lot of us have these reps that come and visit us a lot. And if you don't have the updated version of these booklets, and you can get them combined to the tune of like 150 pages, I think. Home warranty company reps have them. Even some of the NHD reps have them. Okay, so know that it's a resource that's readily available to you guys at any time. So any questions or comments on section B? So we're moving on to section 3, which is B3, right? Continuing on with statutory duties, meaning by law. If you know that the property, and sorry, I got somebody logging in here. So if you know that your property located within 1 mile of former military ordinance or is affected by a zone or district allowing manufacturing, commercial, or airport use, you must disclose that to the buyer. You are also required to make a good faith effort to obtain and deliver to the buyer a disclosure notice from the appropriate local agencies about any special tax levied on your property pursuant to the Melrose Facilities Act, right? The Improvement Bond Act of 2015, and it goes into the section codes here as to why they need to disclose those things. So we're talking about certain taxes on the property, right? You're pretty much telling the seller, hey, Mr. Seller, we have to get this information. Typically, that's going to be on the NHD as well. So just know that it's not going to be that hard to get. So section 4 now, if the TDS, NHD, or lead military ordinance, commercial zone, or special tax disclosures are provided to a buyer after you accept the buyer's offer, the buyer will have 3 days after delivery or 5 days if it's mailed to terminate the offer, meaning that, just remember, and this is just a general rule, anytime you're going to disclose something to the buyer, even though they've removed contingencies, and let's just say that that's the situation, guess what? They now have an open door contingency, right, to cancel if they receive information from you after the fact. That's currently 14B3 of the contract of the RPA, okay, if you want to look it up. But just know that as a general rule. The general rule is if you disclose something to the buyer at any time, regardless of whether or not they remove contingencies on those items, the buyer now has additional time to both review that information and they have the ability to cancel. So, you know, a lot of, I've had this situation one time where there was an investor there was trying to purchase a property, and he had removed all contingencies pretty much when submitting the offer. But come to find out, he ended up canceling the transaction. How did he do that? Well, he ended up doing that because the seller had given him some information like 2 weeks into the game, and he didn't like the information, so he canceled. Well, the seller tried to keep his deposit. It ended up going to court, but the judge threw it out because, again, there's that open door. If you fail to give the buyer all of the disclosures, they have that open door to cancel. And that's what this talks about here. Okay, so let's move on to, well, let's see, we're going to section 5 now. In section 3, the majority of the offsite possibility or possible adversities are disclosed by the NAC where seller may or may not be aware of, right? And in section 4, I cannot reiterate enough how important it is when representing your client to stress the urgency of getting those disclosures out. Now, you probably heard me say this before, that when you take a listing, okay, you should go back to your office. Well, take pictures of the property, a lot of pictures, okay? Every little nook and cranny that you think is just not right about the property, that's your visual inspection, right? But you also have general photos of the property. I think some of you probably remember the story of the gentleman that tried to call me and say, oh, hey, you know what? They took my screen, my backdoor screen. Well, come to find out, it never had one, right? He was just telling me that because he probably wanted me to pay for it. But when I showed him the picture of the back of the house, I said, there's no screen there, right? That pretty much shut him up. But if I didn't have that picture, believe me when I say, is that he would have taken it to the next level, and he would have tried to possibly get the seller to pay for it. And we would have been talking with the listing agent, you know, to try and get that information and or money for that screen door that was never there. So understand that you know, our clients will, you know, they'll fib to us at times to try and get one up on their situation. Okay, but as professionals, if we just go through our normal course of the day, you take a listing, you take a lot of pictures, then you can be choosy as to what you're going to put on your listing, but the rest of it goes in your file. Okay, the next thing you do is you go into the office and you put your disclosures together. I understand you don't have a transaction yet, but you will. And guess what? If you have that information ready, filled out, and you're cocked and loaded, okay, to get those disclosures over to the buyer, it eliminates the buyer's ability to do what we just talked about in terms of canceling. If you happen to forget something, or if you happen to kind of be lagging on getting the disclosures over to them, it puts you in a place of power. And that's, guys, that's what I want. That's the reason why I've been sharing this stuff with you guys, okay? It puts you in a position of power in terms of you got your job done, so guess what? Now it's your turn. And I always use the analogy of kind of like playing tennis, right? The ball's in your court. I just hit it to you, the ball's in your court. So any questions or comments on that? All right, so now we're moving on to section C, death or other disclosures. Excuse me, many buyers consider death on real property to be the material fact in the purchase of property. In some situations, it is advisable to disclose that death, that a death occurred on the manner or the manner of death. However, California Civil Code section provides that you have no disclosure duty where the death has occurred more than 3 years prior to the date of the transferee offers to purchase, lease, or rent the property, or regardless of the occurrence that an occupant of that property was afflicted with or died from. Okay, now this is where it gets weird. Okay, so it's pretty much telling you that the seller has to disclose if there's been a death on the property in the past 3 years, but it's telling you that you don't have to say how or why. Normally, I will just put on there was, you know, passed away from like a normal death, right? But then it gets weird here on the seller's advisory, and it talks about this human T lymphotropic virus type 3. I haven't looked into this enough but I'll be honest with you, I don't even know what it is, but it's telling you that this is the one exemption. If the person died of this, you have to disclose it. So I just found it a little odd. So let's move on to section D. I'll let you guys ponder on that, right? Little homework assignment. Go to your seller's advisory, section C, about death on the property, and look that up, right? You'll be on top of the realtor heap in terms of a little bit of knowledge, okay? But just know that that's the one thing that well, let's read it. See, that this law does not immunize an owner or his or her agent from making an intentional misrepresentation in response to a direct inquiry from a transferee or a prospective transferee of real property concerning death on the property. So just odd why that is. I mean, I really would like to talk to somebody, maybe an attorney at the DRE or CAR, to find out what that means exactly, because I just don't carry that wisdom. So condominiums and other common interest subdivisions. If the property is a condominium, townhouse, or other property in a common interest subdivision, you must provide to the buyer copies of the governing documents, which we all know as the HOA docs, right? The most recent financial statements distributed, which are usually included in the HOA docs, and the other documents required by law or contract. If you do not have current version of these documents, you can request them from the management or homeowner association. To avoid delays, you are encouraged to obtain these documents as soon as possible, even if you have not yet entered into a purchase agreement to sell your property. So pretty much telling the seller, Mr. Seller, we have to give this information out as well. You as the agent, again, you're facilitating the transaction. If it's a condominium or PUD, planning and development, or subdivision, and there's something else out there called own your own, right? Which is also considered kind of like a co-op, right? Do yourself the favor and get this information as soon as possible, because something like this can delay your transaction in terms of getting it sold, okay? If you enter a transaction and then you try ordering it, sometimes the HOA companies drag their feet. And the reason why they do that is because they want to be able to charge you like a rush fee to get them to them. It could be as much as $500. And sometimes you want to pay it. So do yourself a favor, even if you're not under contract, get that information. You're gonna need it at some point. Not to mention the fact that the seller should already have it. So section C is important to understand that the seller has no obligation to disclose anything prior to death occurrence over 3 years. Now, I had a situation one time where the seller was exempt from giving out that information because it was an REO, okay? The neighbor came over and told the buyer, oh, hey, you know what? There was a person that passed away in the master bedroom. The buyer was very upset. Actually went out and hired an attorney. I was helping because I disagreed with her position, but at the end of the day, she calmed down, and believe it or not, we hired a Japanese haiku priest to bless the property. I still talk to that client today. That was probably maybe about 15 years ago. Oh, maybe not that long, maybe 13 years ago. And well, my wife makes cake pops, so I delivered some cake pops to her, but just recently, right? So I still talk to her, and I always ask her, just kind of kidding around, hey, any ghosts or anything? And she says no. She kind of laughs about it. But this is, you know, sometimes it is a very sticky issue when it comes to death on the property. So even though you may not take it seriously, understand that your clients may take a different position. So it is our obligation, again, and our responsibility, we're facilitating the transaction, to disclose this kind of information, right? So section D, the art of good listing agent will use the practice of ordering necessary documents as soon as possible. And I can't reiterate that enough. Okay, when you're working on a file, don't just think that, oh, wow, I just got the listing, so now I'm gonna go relax, you know, I'm gonna go plan my vacation, that kind of thing. No, guys, it's work. You know, what we do is work, and maybe some folks are you know, there's a misconception about what agents do. You know, this is part of our job now, is to compile this information and, again, facilitate the transaction. we are disclosing this to the seller because this is the seller's advisory. We're letting them know, but we're helping them with this stuff and we're getting this stuff done. Yes? Any questions or comments on that previous slide? All right, so contract terms and legal requirements. So let's move on to contract terms. A buyer may request as part of the contract with the sale of the property that you pay for repairs to the property and other items. And let's underline the word request, okay? So whereas not to misunderstand that if a buyer has you under contract, Mr. Seller, it doesn't mean that you have to do the repairs that they're requesting. It's simply a request. Your decision on whether or not to comply with the buyer's request may affect the ability to sell your property at a specified price. So this is where now it gets a little sticky because, well, Mr. Seller, you know what? You didn't want to do those requests. And at the end of the day, that's why the buyer canceled, which is their prerogative. So sometimes those aggressive negotiations and getting your client to understand that we understand that you put a price on your home. We understand that there are things that need to be repaired on the property, but there is going to be a balance in what we call the meeting of the minds. The buyer and the seller have to agree. And if the buyer doesn't agree, they can cancel. That all goes in part with their ability to request those repairs. This is now, and I'll give you guys a little nugget. When you're listing a property, okay, find out as much as you can about that property and put it in your listing, good or bad. The reason why is because it's very difficult for a buyer to request anything that they know something about. But if they go onto the property and something is revealed later on after they made their offer, it gives them the logical ability to request a repair or a reduction in price because that wasn't revealed. They didn't know about it when they made their offer. If they knew about it when they made their offer, it makes it more difficult for them to request anything. Because, and here's an example. One of the things that I do when I take a listing is I go out and I get the termite report. I put that on the MLS. And then I make sure in the private remarks to put on there that the buyer is required to review the termite report attached in the MLS. Guess what? When they make their offer, right? When they make their offer, they've already seen it. They know what's going on with the termite report. Would it be right for them later to request the repairs on it? It's like, no, you made your offer and you saw the termite report. Why would you request that it get done? Isn't that included in your offer? But if they go in, make an offer on a property, they haven't seen the termite report, they go out and they do a termite report and they say, oh, there's $3,900 worth of stuff that needs to get done here. Wouldn't it make sense that now, hey, Mr. Seller, we didn't know about this, but now we're requesting it. You see the reverse? So that's the reason why we talk about it becomes your purchasing power as a buyer, right? When this information is revealed, most buyers understand that trick, right? It becomes your ace card. You know, you go around and you say, oh, well, look at this and look at that and look at this. If it's already been revealed in your listing and it's already been revealed and disclosed to the buyer before they make an offer, it makes it that much more difficult for them to lower the price or haggle with you in terms of requesting repairs. The seller is advised specifically the price is what sells property. And I can't say that enough. There's really only one thing that sells property, and that's price. Consider that any necessary repairs implies cost and effect to price. Of course, if there's repairs that need to get done, obviously there's something called the cost to cure. What is it going to cost to cure that specific item? And every buyer is going to look at it from that perspective because they don't have to spend money on things that they're purchasing. Does that make sense? So let's move on to section 3B. So withholding taxes under federal and California tax laws, a buyer is required to withhold a portion of the purchase price from your sale proceeds for tax purposes unless you sign an affidavit of non-foreign status and California residency, or some other exemption applies and is documented. I'm going to hold an entire class just based on the seller's affidavit, guys, because there's so much misunderstanding about non-foreign status. Okay, so think about it like this. Okay, a person that does not reside in California is considered a non-resident alien. Okay. How is it that they can pay California taxes if they're a non-resident alien? Well, they can't. So the buyer has to withhold it. Okay. The buyer has to withhold it. Now, the majority of people that sell property in California, they live in California. So they just have to say so. Hey, Mr. Buyer, I live in California and I am exempt from this tax withholding. That's all that has to be said. There's nothing else. But everybody freaks out because it's a 2-page disclosure. There's a section for the Social Security number, which we never fill out. It even says it right above it. Okay. All you're disclosing to the buyer is that the seller is either in a trust or it's a company or they're a California resident. So they are exempt from the buyer withholding their taxes. So again, I'm going to hold the whole class on that one, but that even though it's only 3 lines, let me tell you, that's a thorn in my side. So prohibition against discrimination, discriminatory conduct in the sale of real property against individuals belonging to legally protected classes is a violation of law. So a lot of us that have recently taken our DRE, either our continuing education and or licensing education, have recently taken a class on fair housing, understanding that there are protected classes, right? And I was interested to see that a protected class, one of them is like single moms is not a protected class, right? So you need to understand that there are certain discriminatory factors that couldn't apply, but I would just like to make a blanket statement. Why would we discriminate against anybody? This is a business deal. It has to do with money. It has nothing to do with where you're from, what kind of clothes you wear, you know, what your sexual preference is, how tall you are, how short you are, the color of your skin. None of that matters. This is a business transaction. So from my perspective, okay, I like to make a blanket statement that as long as they can proof up the funds and they can give me their loan approval and they can close on this deal, that's good enough for me, right? And that's how the seller should be looking at it. But understand that because there are some legal lines that have been set now for sellers, that they have to pay a little bit more attention to those protected classes, even though you know, to me, if you're leaving people out of those protected classes, that's discrimination in itself. And so I personally disagree with that, and I like to make a blanket statement. So I would simply recommend that all of you deal with it the same way. Hey guys, it's a business transaction, nothing more, nothing more. If you can produce it, you can close it, then why not? Let's get that commission check and let's move on to the next one. As a matter of fact, who knows? Maybe you get some referrals out of that one, right? And I'm not talking about you, the agent, being discriminatory. I'm talking about the seller being discriminatory for certain things. So section B, because this proceeds, I'm sorry, because the proceeds from the sale are coming from the buyer, they're required to withhold a percentage of the sales price by affidavit of non-foreign resident. So we just talked about that. Any questions or comments about that? That's actually a sticky subject for most, but it's really, really easy to think about. So it's 7:06. We're on slide number 17 out of 24. So we're actually moving pretty swiftly. So I'll just keep moving here. So section D, government required repairs, replacements, or alterations under law. Property owners with limited exemptions are required to install operable smoke detectors. And let me see what I highlighted here. Water heater braces and provide a buyer with statement of compliance. Existing operable smoke detectors that met compliance standards when installed do not have to be removed, even if not to legal requirements. Smoke alarms that are added or that replace older versions must comply with current law. Install carbon monoxide detection devices. Some city and county governments may impose additional requirements, including but not limited to installing low flow toilets and shower heads, which actually is a law now that we see on the WCMD for water fixtures. Now, the reason why this is not that important is because all of your hardware stores, Home Depot, Lowe's, Ace, the different hardware stores that are out there no longer carry or sell the old units. Everything that you can buy now is low flow. And that's just a law that was passed some years back. And there is a requirement for homes, I believe, built prior to 1994. You have to get that disclosure out. It's a WCMD, okay? But this talks about now local imposition in terms of gas shutoff valves, tempered glass, and barriers around swimming pools. And you'll find that some counties, like LA County, require those things. And we're getting an unstable connection here. Let me see what's going on. Can you guys check in there for a second? You guys hear me okay? Anybody? I just got
Yes, I can hear you good.
Okay, perfect. It's just because I got an unstable message here on the side here, but thank you, Lupe. Okay, so moving on. The EPA lead-based paint renovation, repair, and painting rule, right? The new rule requires that contractors and maintenance professionals working in pre-1970 housing, child care facilities, and schools and lead-based paint be certified that their employees be trained and that they allow protective work practice standards. The rule applies to renovate, repair, or painting activities affecting more than 6 square feet of lead-based paint in a room or more than 20 square feet of lead-based paint on the exterior. Now, anybody that's familiar with paint knows that lead-based paint lasts longer than paint without lead. They use that kind of like in the marina, right? In boats and stuff like that. The paint lasts a lot longer. And you'll notice that if you go to some of the new housing divisions and you're driving around some of the new houses, you'll notice that the paint is already chipping. And that's because they're not using lead-based paint. Now, lead-based paint, I believe, has been outlawed, right, by the EPA. And it can't be made anymore. So, you have to repaint a little bit more often. But the important thing here is that when lead-based paint does chip, right, it has been known to cause death, especially in kids. And so this is why it's so important. Because if you ingest a chip of that paint, you get lead poisoning. And so this is the reason why lead-based paint is such an issue with us in the real estate field and why it's a required disclosure. Right? It's statutory. It's a statutory disclosure. Any house that is built prior to 1978 needs this disclosure. Okay. And I would say even if the house is built in 1979, I probably would still give the disclosure, right? Because there's probably some lead-based paint floating around that time. But this is a required, statutory item that is required to disclose. And again, because we're talking about the seller's advisory, we're pretty much telling Mr. Seller, we need to disclose this information without actually saying it to them. And then we give them the tool to do that, which is the FLD or the actual disclosure that we're giving to the buyer. And pretty much all they're doing is signing it, right? The information is already there. But there is a space on the FLD where if the seller has done any recent painting, that they disclose who the contractor was and that it was not lead-based paint. So let's move on to section F, right? Legal tax or other implications. Selling your property may have legal, tax, insurance, title, or other implications. You should consult an appropriate professional for advice on these matters. And so there is an ABA that I put together. I expand on this just a little bit, and I'm pretty much telling any seller that when you sell anything, especially a piece of property, it's a taxable event. So I'm reiterating to them that this is very important. It's mainly because sometimes they'll miss it on, when they're looking at the advisory, they just kind of skim through it and they'll sign it. But they really didn't get the gist of what was being said there, right? Because most of us aren't taking the time to talk to our clients about all of these things in depth. Usually we're just kind of summarizing or we're just kind of hitting on it as a point, right? And then get them to sign it and move on, right? But the important thing is that when you do have a seller, this is like very important. They need to understand what's about to happen, because you don't want them yelling and screaming at you after the fact saying, how come you didn't tell me this? Well, guess what? First of all, it's not your responsibility, right? So that's one thing. It's really not your responsibility, but we've already told them here on the seller's advisory. So section D, and sorry, I clicked really too fast here. Health and safety is California law. Note that water conservation has joined in the protections afforded by regulation. So that's the WCMD, the Water Conservation Addendum, which also includes carbon monoxide detectors. And if it happens to be a home that's built after 1994, then you can just use the carbon monoxide detector, which is the CMD disclosure, right? You can use just that. You don't necessarily have to give the WCMD, the newer one, about water conservation, but those disclosures are required. And again, we are discussing this with our seller, and as always, it's not what you know, it's what you can prove. And we proved now that Mr. Seller has signed this advisory, that Mr. Seller now knows that it's required. So section F, please note that many of the matters mentioned cannot be answered by agents as they require different licenses. So if a seller asks you, well, I know you're not an attorney, Mr. Agent, but can you tell me what do you think my taxes will be? Don't answer that question, guys, because you're not an accountant and you're not an attorney. So you would be practicing law without a license, which is a crime. So be careful, with what people ask. I understand that we all want to be helpful. I get it. We want to be as helpful as possible, but believe me when I say that you would be doing yourself a favor by pointing them in the right direction. Now, I've mentioned this before to you guys, and here's another little nugget. Okay, we're actually doing pretty good on time, so I'll include this little nugget real quick. Is that when you guys are out in your travels, get to know some attorneys, get to know some accountants, at least 3 of each, if not more. Not only will you get business from these individuals, but you can give them business. It could the idea of knowing these professionals is reciprocal. You get that question from a client. The first thing you do is you hand them a business card and you say, look, go talk to this guy, he can help you, right? He'll give you the right answers, right? Guess what? That person is going to remember you next time they have a client. And I'm talking about the accountant. Let's say you send your client to an accountant. That accountant is going to remember, oh yeah, I remember Alex sent me this guy. Guys, I've had it happen to me various times. And it's because I created relationships with attorneys, with paralegals, and with accountants. And there's a lot of them out there, and there's absolutely no reason why you can't communicate with them regularly, because there's email database systems that you can blast out information, and it's that constant reminder, I'm still here, I'm still here, I'm still here. Remember what I always say, consistency is the key. But this kind of goes along with one of those things. We are limited in the information that we can give to our clients, so why not partner up with other professionals? If we're telling our clients that you have to talk to these people when it comes to insurance, when it comes to title, when it comes to these legal matters or even tax matters, that gives you the opportunity now to team up with these individuals. And again, when they get a referral, guess what? They're not in the real estate business. They're going to send them your way. It's just how it goes. So that's a little nugget for today. Another one. Any questions or comments on that slide? So market considerations. So pre-sale inspection and considerations. Sorry, I just went my whistle there for real quick. You should consider doing what you can to prepare your property for sale, such as correcting any defects or other problems, making cosmetic improvements, and staging. Many people are not aware of defects or problems with their own property. One way to make yourself aware is to obtain professional inspections prior to sale. And this is what I mentioned earlier about the termite, right? So that was an example. Pre-sale inspections may include a general property inspection, an inspection for wood destroying pests, and an inspection of septic or well systems, if any, among others. So these are examples now of things that you can do prior to actually getting under contract. By doing this, you then have an opportunity to make repairs before your property is sold, which may enhance its marketability. So think of it like this. Let's say that you find out that you have like a little sewer problem and it's going to cost you a couple $100 to fix. Let me tell you what happens if the buyer reveals that there's that sewer problem. They know it's only a couple $100 to fix, but guess what? They might ask for a couple $1,000 in a price reduction. So it actually costs you money sometimes. Oh, I didn't realize Celia's a CPA. Okay, I didn't know that. Celia, that's another hat that you wear, right? Because I think you do loans too, right? You have your NMLS as well. Yeah. So back to whether or not if a buyer reveals something wrong with the property, they can very well now request those repairs or ask for a price reduction. So it behooves the seller most of the time to find these things out on their own. This is true even if the buyer gets his or her own inspections covered in the same area. Obtaining inspection reports may also assist you during contract negotiations with the buyer. For example, if a structural pest control report has both a primary and secondary recommendation for clearance, you may want to specify in the purchase agreement those recommendations, if any, for which you are going to pay. So that's an example that I gave earlier. So I always advise getting a minimum termite report and a title prelim, right? You can market the property with these documents directly on MLS under supplements. And I mentioned that earlier. This section, is emphasizing the importance of the added value that performing repairs to a property can bring. Not always, okay, but most of the time. Anytime I've taken a listing and I've noticed these problems and I've actually told the seller about them, a lot of times, if the seller's willing to fix some of this stuff, they end up saving money because they took care of it themselves. Because in negotiations, you usually pay a little more. And that's just been my experience. So any questions or comments on that slide? That's section 4, marketing considerations. So moving on to slide 19. So post-sale protections, it is often helpful to provide the buyer with, among other things, a home protection warranty plan for the property. These plans will generally cover problems not deemed to be pre-existing that occur after your sale is complete. In the event something does go wrong after the sale and it is covered by the plan, the buyer may be able to resolve that concern by contacting the home protection company. So this is just one of those things that you're pretty much, you're giving the buyer some peace of mind. Typically a home warranty would be like anywhere between $550 and let's say $600. That's on average, right? They're more or less just depending on the property, depending on the amenities and the utility of the property. But for the most part, it's kind of giving the buyer peace of mind that if something does go wrong, because, hey, we weren't able to reveal it through home inspection. We weren't able to reveal certain things through seller disclosure. We weren't able to reveal certain things just visually. So these are the things that we don't know about. So guess what? We'll add, some of the things that may cost money, like say pool equipment, air conditioning and heating equipment. Sometimes appliances can be covered under home warranty. So there's a lot of different things. One of the things that I would suggest is all of you guys go onto a home warranty site and take a look at their brochures and take a look at their different payment plan, not payment plans, but the price points for those home warranties. Because when you're writing your offers, I'm finding the majority of you are not looking at that first. So when you ask the seller to pay a certain amount of money, a lot of times it's short. So understand, always try and pad your amount by $10 or $20 And if the seller ends up paying less, it's okay, but at least you're covered, or it's not coming out of the buyer's pocket. So let's move on to section C, okay? So advertising and marketing your property for sale included, but not limited to holding open houses, placing a lockbox, erecting a for sale sign, and disseminating photographs, videotapes, and virtual tours of the premises may jeopardize your personal safety and that of your property. You are strongly encouraged to maintain insurance and take any and all possible precautions and safeguards to protect yourself, occupants, visitors, your property, and your belongings, including cash, jewelry, drugs, firearms, and other valuables located on the property against injury, loss, theft, vandalism, damage, and other harm. Which is kind of obvious. It's one of those things where, you know, you would think that everybody thinks about, you know, but it has to be said. Again, it's not what you know, it's what you can prove. Oh, somebody stole the watch out of my house, you know, well, I'm blaming the agent because, you know, he never told me anything. Well, guess what, Mr. Seller? I did. You signed the seller's affidavit, and it says it right here that you please, number one, insure the items in your property, but number two, put your things away. You've been told. Now, I take that position, guys, but let's take a lighter position, okay? If you take a listing, some of you may want to just have a nice little flyer for your seller when you're doing an open house, repeating this just on that flyer. You know, you don't have to have them sign it, but hey, Mr. Seller, look it. I'm gonna have an open house in a few days. This is what's happening. You know, now we're just acting professional and diplomatic with our clients. We're not going to take the position of, well, you know what, I told you so, and you sign this paper. You know, I would hate to take that position with folks, right? So just to act a little bit more professional, that could be a consideration of yours in terms of putting something together and letting your client know about this stuff. And then if you happen to see something that looks like it might get stolen or whatever, you know, mention it. You know, we're the professionals and we're trying to help our clients, right? So moving on to expenses, you are advised that you, not the broker, are responsible for the fees and costs, if any, to comply with your duties and obligations to the buyer of your property. And let me tell you guys something. I've had various listings cancel for whatever reason, and then for whatever reason it ends up that they don't, you know, maybe they don't end up selling or whatever the case is. But you know, a transaction coordinator, and I'll speak from experience, we do the majority of the work for the agent, right, of the stuff that's supposed to be happening. So understand that a lot of the stuff that a TC does is agent work. It's not work that's being done, you know, by the TC. The only thing a TC does realistically is check that the disclosures are signed and dated. They're not even responsible for what the disclosures say, because they're usually not licensed to do that. But if a file cancels, understand there was a lot of work that went into that. So this is something that sometimes you can flow over to your client, and it's already been told to them that they're responsible for the fees and costs. So if your transaction coordinator happens to have a cancellation fee, guess what? The seller sometimes could be responsible for that. So section B can cover anything that happens in the future with home warranty, which we talked about. Section C covers what an agent will do potentially, as well as warning the seller to put their valuables away. And section D, and lastly, how many of you have been faced by a seller that wants you to pay their fees? This is where you would reference this issue. Okay, so you know, sometimes in terms of brokerages, you know, a listing agent might spend a lot of money to list their property. You know, they might have special photography done, possible staging, you know, the signage, you know, open houses in terms of time, you know, those marketing materials, it can get into the hundreds of dollars. And so who's really responsible? I would say that most agents and brokers never say anything about it, but understand that in the seller's advisory, you're actually telling the seller that they're responsible. So if you care to hold them responsible, that would be your prerogative. Any questions or comments on that? All right, so we're moving on to section 20. And we've gone over this before, but again, I like to reiterate this. Caveat emptor is a Latin term for buyer beware, right? The principle of the buyer alone is responsible for checking the quality and suitability of goods before a purchase is made. But the seller of a product cannot be held responsible for its quality unless it is guaranteed in a warranty. That's interesting, because the seller's only obligation is to disclose. It's not, their obligation is not to give the buyer a warranty. Now, there are homes that do come with warranties, and those typically are ones that we find that are new, right? But the majority of homes that we sell are not new. So the seller's not giving any warranty. This is why the buyer now has a responsibility to inspect and to be responsible to check the quality, condition, and suitability of a property, right? Any questions or comments on that? The caveat emptor, right? I know we've talked about that before, but again, I was throwing these little reiterations. Does this legal term mean that the seller is not obligated to disclose? And I think I just answered that. No, the seller is obligated to disclose unless they're exempt from certain disclosure. One of the most misunderstood terms in real estate is the as-is clause. And we talked about this a little bit earlier. And I don't know why I don't remember this being here, but it is slide number 21. So I'll just go through it real quick. The as-is clause does not reveal a seller from, or I'm sorry, does not relieve a seller from the duty to disclose all the material facts to a buyer or a real property. However, an as-is clause does signal to a buyer that the seller will not be responsible for the cost of repairing any defect. Thus, whether the contract contains an as-is clause or the property is sold with certain warranties, real estate licensees should continue to encourage sellers to disclose any known defects in the property. Okay, so that was actually the last slide. Okay, so moving on, let's go on to final thoughts. Before I do this, any questions or comments so far? Okay. As discussed in the section for sale by owners, selling real estate is not that easy and carries much liability. A licensed professional is an added benefit to those who seek to sell with little or no worries. If you as an agent apply the appropriate explanation to your client or a prospect, you, along with these forms, can represent your client honestly and with a very certain level of integrity. Listing a property with you becomes the obvious choice. So, hey guys, just knowing, even though we talked about, we haven't even gotten into the listing agreement yet. We've only talked about today. We've only talked about the agency disclosure, and now we've got into the seller's advisory. The seller's advisory really does say most of what needs to be said to a seller, other than what we're agreeing to now in the terms and conditions, like price, commission amount, whether or not we're going to put up a sign or a lockbox, whether or not we're going to put it on MLS, is there any leased property or leased items on the property, right? Those are different things that we're now engaging. But in terms of what needs to be said to the seller's advisory covers most of that, along with the agency relationship. So if you guys have a really good, pure understanding of that, and I recommend that you guys go and read this stuff, like I always say, okay? And don't do it all at once, do it over time. I'm already on page 8, I think, on the new RPA. And I've been doing it like, I'll do like a page or two every other day, something like that, okay? So by the time the 21st rolls around, I'll have a pretty good working knowledge. And what I've read so far is that there's not that many changes. There has been a lot of reiteration on the RPA because there were things that weren't very clear on the previous one that I now see they're clarifying. But in terms of changes, there's not a lot of them. I haven't heard anything about the listing agreement. I don't think they're going to be changing any of that as of yet. Okay. There has been some changes in terms of the clear cooperation and also the coming soon option, as well as the SELM, which allows you not to put it on MLS if you list the property just depending on the seller's wants and needs. But next week, we'll be covering the actual purchase, or I'm sorry, the actual listing agreement that gets into those things. But do yourself a favor, take the time to read the seller's advisory. It goes along with everything that we should be telling our clients, and we've taken that additional step of getting it in writing and then getting them to sign it. They have been forewarned, in other words, right? So any questions or comments? So there's Shamim, and I forgot to put that under the animation part. So she popped up right away. So normally it's me coming up first. My website is down right now at current as I'm doing some maintenance to it and what have you, but I should get that up soon. There's not really much on the website, but I was hoping to get up some other stuff. Mr. Larry, I usually see him here, but he's not here today for whatever reason, maybe on vacation. You know, December is always a tough month, but there's his information if you would like to, speak to him about any title information or if you happen to, hey, you want to try and build your business, Larry can help you with that, okay? You're welcome, Celia. Looks like I missed her. Thank you, Robert and Sully. Always good to see you guys. Liz Montes, she's here at Uptown Realtors. She's also the owner and operator of ERA's Mortgage. There's her information. If you guys need a pre-approval or have a question about a loan or what have you, she can help you with that. And then the gentleman that I always endorse for motivational training, which I highly encourage most of you to go listen to, is Mr. David Plummer. I endorse his product. He's very good at what he does. I do something a little different in terms of, contracts, disclosures, and advisories, right, and reports and concepts, right? So it's more technical. Dave is a little bit more on the tactical side in terms of your ability to go out and get business. So that's what Dave concentrates on and talks about. I always love listening to him. Whenever I listen to Dave, I feel like running out and just going to talk to people, right? Because it's just how he makes you feel. But anyway, that said, thank you guys for coming on. We'll be doing part 2 next week and then part 3 the following week. We'll be taking a little vacation now, right after Christmas, and then coming into January. I think the first class we'll do now in January, I think is on the 12th, if I remember correctly. So we're going to skip a couple weeks and have a nice little vacation there. I hope everybody has a nice holiday. But we will be covering part 2 of the residential listing agreement, which is of 3 parts. We'll be covering that next week, and then the following week we'll do part 3, and then we'll go into the holidays. So thank you guys for logging on. We're at 7:34, so we did a good time. Any questions or comments otherwise? All right, well, good seeing you guys. Again, I'm not an attorney or an accountant. I just humbly like to share this information with you guys and just try and learn as a group. And any questions or comments you guys might have, you guys have my information. Welcome to call me, welcome to email me. I'll get to it as soon as I can if it happens to be during the busy time. If not, most of the time I get long-winded, so my apologies for that. Okay, but anyway, other than that, hopefully you guys have a good week and a productive week. And I will see you guys next week, okay? I'm going to be logging off.
Thanks, Alex.
All right, good. Thanks again, Mr. Dion.
Thank you, Alex.